Okay, I will start by acknowledging the traditional custodians of the land in which we meet today, the Valamatical clan of the Arab nation, whose customs and cultures have nurtured and continue to nurture this land from the dream time. I pay my respects to the elders past, present, and emerging. So these are the contents of my presentation today. I arranged my presentation along 6 key themes: the problem towards the solution, theoretical justifications, lessons from local and indigenous worldviews, lessons from comparative jurisdictions, and the river person model. I will also briefly explain the methodology that I use, because this presentation is based on my PhD research. So for the PhD research and for this research, I use 3 methodological approaches: the blacklight approach to research, socio-legal research methodology, where I conducted 32 semi-structured interviews with several key stakeholders in Sri Lanka, and international and comparative research methodology, where I drew lessons for law reform from Ecuador, Aotearoa New Zealand, India, and Bangladesh. Now I will move on towards the first part of my presentation, the problem. So what is the problem that I sought to address in my research? My research focused on Sri Lanka. Sri Lanka is a small island of 65,556 square kilometers, roughly the size of Tasmania. Despite its very small landmass, Sri Lanka has 103 rivers, 80 seasonal and 23 perennial. If you look at the map provided in the slide, you'll be able to see all these small blue lines starting from the middle of the island, then flowing into the ocean from all sides. Now, the thing about the rivers in Sri Lanka is that they are not mere natural entities, physical entities, or exploitable natural resources, but for many Sri Lankans, rivers are understood as relational beings. What does relationality mean? Relationality embraces the interconnectedness between separate categories, for example, human and non-human, and it decenters the human beings as the accepted privileged norm and recognizes humans as embraced within a network of related beings, the more than human community. It embodies values that emerge from meaningful human-river relationships, emphasizing care, reciprocity, responsibility, and stewardship. I will draw on 2 examples to show how relational the rivers in Sri Lanka. I have many examples, but due to the time limits, I will only use 2. According to the Sinhalese Buddhists in Sri Lanka, rivers are considered to be the dwelling place of the divine. For example, Godgange Bandari is considered to be residing in the Huluganga River, and Godranwal is considered to be residing in the Kalani River. You can see a picture of Godranwal on the slide. Then I also did interviews with the indigenous Vada communities in Sri Lanka, and according to them, the rivers are the dwelling place of the ancestral beings. One of the elders that I interviewed said that whenever Meyato is the word that they used to refer to themselves and their community as a whole, steps into the jungle, Meyato sense the presence of the spirits. Nayaku means the ancestral spirits. Rivers, streams, and small streams, all of these are their abode. So accordingly, for Sri Lankans, rivers are not physical entities or natural resources, but rather metaphysical entities deeply intertwined with relationality. What is the representation of this relationality within the legal framework in Sri Lanka? This can be discussed under 2 topics: pre-colonial and post-colonial. Before the arrival of the colonial rulers, the legal system in Sri Lanka was predominantly consisted of customary laws. There were these laws were so intertwined with how people lived, adapted, and interacted, making it a reflection of the lived reality. Sri Lanka did have kings, but the king was not considered as the source of law or even the repository of law. Even the kings were expected to respect, protect, and uphold the customary laws in the country. So within this pre-colonial legal system, relationality with rivers had the force of law. However, this all started to change with the arrival of the Europeans. Sri Lanka was under the control of 3 European rulers: the Portuguese, the Dutch, and the English. And they did a significant, massive influence on the legal system in Sri Lanka. And as a result, today, the 2 dominating legal systems of the country are Roman Dutch law and English law. And the customary laws eventually marginalized, and some even got extinct. Today, only 3 customary laws are in operation, but they are also applicable only with regard to a very limited number of personal matters like marriage, divorce, inheritance, etc. Now, when we are looking at the river governance framework in this context, river protection laws in Sri Lanka today contain over 50 pieces of legislation enacted during and following the British colonial rule. Therefore, this river governance framework carries a strong Western legal foundation. What is the issue with this is that the Western law is considered to be hugely anthropocentric because of the worldview on which it is based. And separation and hierarchical ordering of human and non-human beings are considered to be at the very foundation of Western law governing human-nature relationships. So there is a fundamental incompatibility with the river governance legal framework of the country and the relational realities in Sri Lanka. So this is the gap that I sought to address, bridging the gap between relationality and anthropocentrism and the gap between local and indigenous legal systems and the imposed Western legal systems. So what is the solution? One would see, okay, why don't you return to a plural legal system? But in the Sri Lankan setting, returning to a plural legal system is far more complex than one would imagine, because there are 4 reasons that I identified. Colonial legal frameworks remain deeply embedded in the current system. Second, colonial processes led to the disappearance of many local and indigenous legal traditions. Thirdly, reviving plural legal orders may have implications beyond human nature relations. This is too risky given the prominent ethnic tensions in the country, which is again a creation of colonial rule. Then finally, integrating multiple legal systems within existing institutional structures, which derives from the colonial heritage, may represent practical challenges. So as a result, there is a need for mechanisms that bridge relational worldviews and state law without generating unintended consequences. So, I picked legal personhood and rights of nature as a suitable mechanism. What is legal personhood and rights of nature? It recognizes natural entities as legal persons with rights. Today, at least 24 jurisdictions around the world recognize legal personhood and rights of nature through various constitutional, legislative, and judicial mechanisms. Kaufman and Martin says that the rights of nature has become more mainstream now. And when we are looking at the recognition of rights of nature around the world, such recognition in India, Bangladesh, and Aotearoa, New Zealand is directly linked to the rivers. I have several justifications why I suggest legal personhood and rights of nature provides a pathway to relational governance. The first one is it creates a pathway for the local and indigenous communities to effect legal change and embed relational responsibilities towards rivers within the Western influence anthropocentric legal frameworks. Secondly, it reframes the rivers from an object before the eyes of law to a subject before the eyes of law. Thirdly, the substantive rights given to the rivers can protect the interest of the rivers, and the procedural rights given to the rivers can allow them to be represented within the human systems. Fourthly, it imposes duties on different stakeholders, including the government parties, to safeguard the rivers for more than instrumental values that they hold. Fifthly, these two concepts ensure that the harm suffered by the river itself will be taken into account in assessing pollution depth. And finally, it contributes to decolonizing pollution. What does it mean? For us, pollution means some level of pollution is allowed as far as it does not adversely affect the human beings and certain aspects that they think must be protected. So this colonial conception of pollution can be addressed through legal personhood and rights of nature. However, at the same time, I accept that these two notions have limitations. Legal personhood and rights both are Western legal constructs. They have Western legal origins and they have Western ideological roots. So there is always the risk that these two concepts confining the rich relational ontologies within narrow confines unless it is framed very carefully. Then, I also had to find theoretical justifications. Now, I say that, okay, legal personhood and rights of nature is a good mechanism for relational governance of rivers, but is it theoretically possible within the existing jurisprudence? So when we are looking at the theories governing the legal person, there are two basic theories, legalist and the realists. Legalist says that anything and anyone can be a legal person if they satisfy certain conditions. But realists, on the other hand, says that the legal person is an expression of some important defining attribute of human nature. So from these two approaches, I picked the legalist approach to justify rivers as legal persons. So the legalist says that rivers, of course, can be legal persons, but there are conditions to be satisfied. They should either have rights and or duties or have the capacity to hold rights and or duties. Why do I say rights and or duties? It's because there is no consensus among the legalists as to whether a legal person should hold both rights and duties or either rights or duties. However, I will justify that rivers have both rights and duties to be said. Now, when we are looking at whether rivers hold rights, according to the Western, understanding of the rights, It does not conceive natural entities such as rivers as capable of holding rights. Usually, rights are only reserved for the human beings. But there are criticisms for this narrow understanding emerging within the Western jurisprudence itself. One example is jurisprudence. Earth jurisprudence rejects the idea that the human beings are the superior beings and the rest of the nature are inferior beings, and they say that we are a communion of subjects, not a dominion over objects. And the proponents of Earth jurisprudence says that the natural world, including all its components, thus rivers, possess inherent rights that stem from existence itself. That means we do not have to confer rights on the rivers, rather they do already have rights because they came into existence. And they recognize three ecological and functional rights: the right to exist and flow, the right to habitat, and the right to fulfill their role in the ever-renewing processes of the earth community. Now, looking at the other side of the coin, do rivers perform duties? The issue with the duties, once again, is we usually look at duties in a very human-centric way. What kind of duties can rivers perform for human beings in their societies, etc.? But what I suggest is we should look at this question in a wider angle, taking not just human communities, but more than human communities, and determining what kind of duties do rivers perform towards the more than human community. When we look at this question this way, there are two roles that the rivers play. Rivers perform a range of complex duties for the earth and its members, like maintaining balance, sustaining biodiversity, etc. And relationally, they perform relational duties as well by connecting communities to their cultural identity, sustaining, communicating, and shaping their ways of being. Now, the ultimate question for part 3, are legal personhood and river rights legally possible? Theoretically possible. The answer is yes, because rivers do have rights, they do perform duties, therefore they can be legal persons. Then I also had to, now it's theoretically possible, but whatever they are raising the theory, I have to adapt it to the social, legal, political realities in Sri Lanka, because I'm developing this model to be applied in Sri Lanka. So in framing the legal person model for rivers, I drew lessons from local and indigenous worldviews and the comparative jurisdictions. When I interviewed and I did my research for the to determine the local and indigenous worldviews, I realized that Sri Lanka is a hugely multi-ethnic, multi-religious country. I would not be able to interview all these communities and look at all these worldviews. Therefore, I picked only two: Sinhalese Buddhist communities and indigenous Vada communities. So when I did my field work as well as my desk research regarding the Sinhalese Buddhist worldview and how they connect to the rivers, the basic thing is they do not understand rivers as mere physical entities, but for them, rivers are metaphysical entities. And also their understanding and their relationships with rivers helped me frame 3 rights, which I can add to the rights framed by the jurisprudence theorists: the right to have their own consciousness, reason, competencies, and capacity for awareness respected, the right to be acknowledged and protected as sacred places, the right to connect to human communities through cultural, spiritual, stewardship, and other non-instrumental relationships. This was mostly similar for the indigenous Vada communities as well, but with the engagement with the indigenous Vada members gave rise to another new right, which is not there in the Sinhalese Buddhist worldview, that is the right to be recognized as alive and sentient. Then I also looked at the comparative jurisdictions. What lessons can I draw from these comparative jurisdictions? So as I said, I looked at 4 jurisdictions: Ecuador, Aotearoa New Zealand, India, and Bangladesh. When we are looking at these comparative jurisdictions, Ecuador follows the rights of nature model. That means it recognizes the rights of all of nature in the constitution. All of the other jurisdictions, they follow the legal personhood model. They declare the natural entities as legal persons. So all of these models, they have their own strengths as well as their own weaknesses. So when we are looking at Ecuador, relational ontologies, the reliance on the relational ontologies is a good lesson to be learned. They draw inspiration from indigenous Andean worldviews, particularly Pachamama and Sumak Kauza. Then they also recognize the substantive rights for nature, which is a plus point. However, the Ecuadorian lesson also point out that the constitutional recognition per se is not adequate. There has to be complementary legislative and administrative measures to really give effect to the rights of nature. Then the role of the judiciary, Ecuadorian experience shows the role of the judiciary can play in giving shape and form to the constitutionally recognized rights of nature. And also, the implementation model in Ecuador is a plus point. They allow anyone to approach the court to protect the rights of nature. This is particularly an important lesson in Sri Lanka, where the environmental jurisprudence is basically led by the public-spirited people through public interest litigation. Then looking at Aotearoa, New Zealand, again, the relational ontologies is a very important lesson because their Teyawa Tupua model, the legal personhood of the Wanganui River, draws from the relational ontologies of the Maori communities. Specifically, the intrinsic values mentioned in the legislation says Ko Aoteawa, Koteawa Koau, I'm the river and the river is me. Then, one of the issues with the Aotearoa model is that they do not have clearly defined substantive rights given to the rivers. Then thirdly, the New Zealand model does not vest all the elements of the river system in the river itself. This includes even the water. Water is not particularly vested in the Wanganui River. However, the guardianship model in Aotearoa, New Zealand is a plus point because it's represented by the state as well as the Maori communities. And also, Aotearoa example shows the need to prevent rivers from being sued for monetary compensation. There is always a risk of attaching legal personhood to rivers because the people might try to sue the river for monetary damages as well as for murder even if someone got killed because of flood or something. Then looking at India and Bangladesh, lessons are more or less similar. In India, the justification is drawn on the spiritual and religious significance. Hinduism, how River Ganga is considered Gangama. And even in the Bangladesh judgment, Turak River judgment, the court referred to several plural worldviews. Then both cases showcases the role of judiciary in protecting the rivers and bringing in innovative approaches to protect the rivers. And also in both cases, the legal personhood of rivers was used to protect the rivers against pollution as the ultimate mechanism to protect the rivers against pollution. Then, however, in both cases, in India and Bangladesh, in their models, they do not have a clearly defined set of substantive and procedural rights. That can be a bit of a weakness in the two models. Then both India and Bangladesh lay down a guardianship model, but it does not have a multi-stakeholder representation. It only focuses on the state officials. So drawing on all these lessons from theory, from local and indigenous worldviews, and from the comparative lessons, I developed my river person model for Sri Lanka through a separate legislation. However, I also had to address another question before framing the river person, because I was asked by many people which category are you putting this river person into. What I say is neither of the existing two categories, the natural legal person and the artificial legal person, is not adequate enough to encompass the unique personality of the river person. Therefore, what I suggest is it would be more appropriate to recognize the rivers as a new category of legal persons, which is river persons. So I made suggestions for the development of a legal personhood and rights of rivers act. And this act, I suggest, should recognize all rivers flowing through Sri Lanka as legal persons. However, legal personality is to be understood as inherent to each individual river. Not all rivers will be one legal person, but rather each river would be individual legal person. And also it is important to specifically mention rivers are not just physical thing, but also the metaphysical entity as well. Then I also laid down several substantive and procedural rights, drawing on all the lessons that I learned. You can see them in the slide. I'm not going to read them out. Then I also had to specify a mechanism for resolving the conflicts, because obviously there's going to be conflicts between human rights and the river rights when this model came into existence. So what I suggested is that conflicts should be resolved in a manner that ensures the best interest of the wider more than communities and does not adversely affect the physical and metaphysical role of the rivers. Then I also suggested that Sri Lanka should adopt a specific provision which says that the rivers shall not be subject to litigation and cannot be sued before any court of law in order to avoid unintended consequences of conferring legal personhood to rivers. Then implementation mechanism for the river personhood model is a combination of the lessons from Ecuador and all other 3 jurisdictions. There is a river guardianship council consisted of 6 ex officio members and 6 appointed independent members. And there is also a public enforcement element where any member of the public, community or nation may file or petition the Court of Appeal in Sri Lanka in case of violation as well as imminent violation of the rights of the rivers. So this is basically what I did, how I developed the river person model, and I will provide the conclusion now. Sri Lanka's rivers are understood within many local and indigenous traditions as relational beings. However, this relational understanding remains largely unrecognized within the state-based legal framework, which continues to treat the rivers as resources to be managed and exploited. Legal personhood and the rights of nature offers promising pathways for addressing this gap, but their effectiveness depends on how they are framed and implemented. When grounded in relational principles, these approaches can move beyond symbolic recognition to reshape legal responsibilities and environmental governance. In this regard, the river person model offers a constructive mechanism for embodying relationality within the law, seeking to align legal protection with the lived cultural, ethical, and ecological responsibilities and relationships that sustain Sri Lankan rivers. With that, I finish my presentation. Thank you so much.
Okay. Thank you, Asanka, again for sharing your very insightful work. I'm always, having known you since you started your PhD journey at the law school here, I've always been very interested in the application of these different concepts and theoretical frames to a practical legal situation as you did in your thesis. I think that challenge is something which should never be underestimated. It's incredibly difficult to take concepts, theoretical frameworks as you have, and apply them to a legal system that operates and exists as it does day to day. Now, before I go any further, I just want to double check how we're going for time, given that we started a little late. Are we still aiming to finish at 3? Yeah.
Maybe we can go a little beyond if needed.
Okay, but I'll cut short my response to make sure that we have enough time for any questions from the audience. Asanka? Yeah. Okay, great. So, well, I already said that I've always found Asanka's work to be very important and brave in that sense. I think it's difficult enough to speak about these themes, relationality. It's not something, as Asanka pointed out, that is a part of any legal system, the one we have in Australia, of course, any legal system that has been imported from Europe, as is the case in Sri Lanka as well. Relationality is not a natural part of that legal system. So just understanding the concept and its relevance to, for want of a better word, Western legal models is difficult in of itself, but to then show how it can or cannot be practically applied, as you showed in your analysis, is, I think, a very important step. I think as well, as I mentioned, following my acknowledgement of country earlier, relationality is still very strongly associated with First Nations Indigenous legal frameworks, naturally so. But what you've shown as well, Asanka, is that it does go beyond that. I think in international law, Indigenous groups, Indigenous people and local communities are often seen as quite close together, but there are differences. And I think you made an interesting distinction in the latter parts of your presentation. Within Sri Lanka, you had that chart and you distinguished the Indigenous group at the bottom to the Sinhalese group and their understanding, I suppose we'd call it, of relationality through religious practices, mainly Buddhism, and I guess to a lesser extent, perhaps Christianity. And I think that's really important because relationality is a topic which has really gained prominence in environmental law scholarship in the last, say, 5 to 10 years. But there needs, I think, now to be a bit more of the next step. And I think that is to look at where does relationality find traction, find importance in groups that include, but also maybe go beyond First Nations and Indigenous people. So I think that's a very important contribution, again, of your work. I think what's interesting as well, going to some of the final points you made, is you used in your comparative examples. One is you use what's it? Sorry, was the first one? Sorry, not Venezuela. What was the first one? Sorry, Ecuador. But also the one that I found most interesting is Aotearoa, New Zealand, where it isn't a constitutional right, as you say, but the importance of litigation there, I think, is something, because in New Zealand, the main environmental legislation is the Resource Management Act. But despite its name, the Resource Management Act has been interpreted and applied in such ways that promotes tikanga Maori. And tikanga Maori is something which has started to influence the application of common law in New Zealand. And I'm not sure, Asanka, I'll give you an opportunity, obviously, to respond to all these points in a moment, but I'm not sure if you're familiar with the case from 2024, which I believe is still to be resolved, a case called Smith and Fonterra, which is, I guess nominally you would say, a climate change case, climate litigation, but looks specifically at questions of stewardship and tikanga Maori, and how obligations are undermined by climate impacts, and what this means then for how the interpretation and application of common law as it has existed under the New Zealand system, I suppose since the days of colonization of New Zealand. So interested to hear your thoughts on that. And I suppose another point, going to this idea of stewardship, and again using perhaps Aotearoa, New Zealand, as an example. You spoke there in your framework at the end there, the framework for moving forward. You spoke about including a provision which precludes suing a river. Now, this is an interesting one to me, because I remember, just to give the audience and in the room and online a little bit more background, I actually sat in on one of your earlier presentations of this. You probably remember now, and a similar question came up. And whilst you said, you cannot sue the river, and you used the example of murder or loss of life, which I understand, fairly extreme example, but I understand that. But I'm interested to hear as well, though, and it goes a little bit to my question to you some years ago now. When it comes to human rights against rights of nature, in this case, river, which one will win out? Because there will inevitably be a contest between the two. So I don't want to necessarily talk about murder, which is obviously a crime. I'm thinking more about here climate change adaptation and flooding and these sorts of issues. Like, do people need to move to allow the river to flow into areas it hasn't flown previously because of climate change? Or if you dammed the river, is that a contravention or infringement of the river's rights? So that's, just a couple of points I'll pass over to you now.
Okay, so regarding what you pointed out regarding the indigenous communities, I actually want to point out that in Sri Lanka, particularly drawing on my example, indigenous communities, the first thing that they're struggling with is establishing that they are really indigenous. Because indigeneity, according to the mainstream understanding, starts from when the European settlers arrived. But in Sri Lanka, according to the written history, the Sinhalese Buddhists as well as the Tamils, they all arrived on the island from India. By the time they arrived, the indigenous Vanda communities were already there in the island. But I don't think, from what I found, like the policymakers, the lawmakers, and even the legal scholars, they do not accept that indigeneity, the concept of indigeneity applies in Sri Lanka. I think it's not only for Sri Lanka, which the argument is there. There are so many other countries in Asia where they argue that indigeneity is not a concept which applies to us, because I think it's because of the mainstream understanding of indigeneity. So yeah, I actually had to separate, like distinguish between the Sinhalese Buddhists and the indigenous. I refer the word local to refer to the Sinhalese Buddhists and indigenous to refer to the indigenous Vedda communities. But yeah, so we cannot really put all of them into one basket and say that they are similar, because the relationalities with nature of the Vedda communities are distinctive. They are deeper, more stronger than those of the Sinhalese Buddhist communities. But the issue is, in Sri Lanka, these communities are seen as a primitive form of people. That's why they are living so close to nature. So that's an issue. So regarding what you pointed out, in Aotearoa, New Zealand, I do not have a very thorough understanding of how things work there. But I do know that even the legal person who wrote of Te Avatupua is not widely supported by some of the Maori communities. And they see it as another imposed colonial construct on them.
Yeah, so if I make a comment about that, I think, yeah, that's another really interesting point I've always found with this, and I'm sure it's a tension. Well, obviously, it's a tension that you came across in your research as well. Is that rights? Now, whether we want to recognize the rights of nature, now that could lean into a better understanding of relationality. But as you just sort of alluded to there, rights in any sense are a Western construct. And yeah, so sorry, if you please continue that point, that it is still perceived by at least some Maori as, yeah, an imposition of what is still I suppose, the legacy of a colonial, well, not a legacy, it's I guess, post-colonial, neo-colonial regime, yeah.
So yeah, but what I believe is that in terms of what happened in Aotearoa, New Zealand regarding the legal personhood of Te Avatupua, I think it's not the personhood of the river which is important. It's the rest of the provisions in the Te Avatupua Act which can be considered important, and providing for the protection of the relationalities and values and Maori Tikanga. Yeah. So, and regarding the third point that you made regarding HR and rights of nature, I don't think I have like a proper answers to how this should be solved or resolved, where there is a conflict and things like that. But I actually, when I did the presentation, I sort of thought that perhaps how can this be resolved, because this is too complex, complicated. There are so many parties involved, not just the humans, but the more than humans, and like the trees, flowers, and so many parties. So if there is a conflict between the human interest and the interest of the nature, human rights and rights of nature, if we can take into account the best interest of the more than human community, not just the humans, but think about this issue by placing the human beings within the wider network of relational beings, it would be a good way. But I know theoretically it's a good mechanism, but I don't know how practical that is. Yeah.
Yeah, okay. Thank you. Okay, so just looking at the time then, I think we can take some questions from the audience, both in the room and of course online. So if you're online, please just raise your hand using the icon thing on Zoom, and we'll get to you. We'll go to Max first. Max, you're up.
Hi. Thank you so much for that. My question's kind of about measuring success. You've mentioned a bunch of case studies. Do you have could you discuss a little bit more the kind of evidence that the legal personhood model is more effective, given the complexities that it involves with rights and rivers being sued and all the other problems associated with it that you've rightly identified? is there evidence to suggest that it's worth it, and that it actually effectively protects the rivers more than other mechanisms?
That's a very good question. Well, if we are looking specifically at the legal personhood model, I did not find a lot of literature done on the Aotearoa New Zealand model's implementation. Like, there are so many literature which talks about how it has been framed and everything, but not about the implementation. But if we are looking at India, India's two judgments were stayed by an order given by the Supreme Court. And so I think we are yet to see how effective that is. But then again, with regard to the value of those two judgments, there were other subsequent judgments. Even though that two judgments were stayed by the Supreme Court, there were subsequent two judgments which recognize the legal personhood of all of Mother Earth in India by Madras High Court, and another case, Sukna Lake case, recognizing the legal personality of the Sukna Lake. But honestly, I think in both of these countries, the effectiveness, the real effectiveness of the two models are yet to be seen. But if we are looking at Bangladesh, in Bangladesh also, the immediate reaction for the judgment is an appeal brought in. But then again, the higher court allowed the judgment to continue and to be in force, subject to certain modifications that they did. So in a case of Bangladesh, they had already started working on the judgment and removing certain illegal settlements made on the sides of the Turak River. So it's, I believe that it showcases that the judgment did something which could not have been done today previously. Like previously, within the existing laws, these illegal settlements could not be removed, but after the judgment, the authorities went ahead and removed the illegal settlements and everything, which I see as a positive step. But if we are looking at the Ecuadorian case, Ecuador, they do not follow the legal personhood model, rather rights of nature model. But then again, they have a very comprehensive jurisprudence now developed, defining the rights of nature in different ways, in different progressive ways, and defining how to reconcile the human rights and the rights of nature, and how they can be applied in mining and all these other commercial related activities. And rights of nature, at the time I did the thesis, was invoked at least in 55 cases. And also it has been used by the indigenous communities to protect their rights. So I think the Ecuadorian example provides a very positive direction. Okay, rights of nature can do a lot, but I think in the cases of Aotearoa, New Zealand and India, the change is yet to be seen.
Okay, thanks, Max. Next question, Peter. Go ahead, Peter.
Thank you. Thanks so much for a really interesting presentation. I'm kind of doing something for my PhD that is related to your research. And so I really want to take the opportunity to ask a question. It's about in Sri Lanka, whether you see it as feasible, or has there been any attempt to sort of write river-based governance into a higher law, in order to protect not only the rivers, but the ecosystems that all relate to the rivers. I ask this because in the context of my thesis, I'm looking very closely at how China's grappling with administrative boundaries that prevent that. And so they're trying to override that by putting ecological governance on the basis of river basin governance rather than simply limited in the, boxes of administrative jurisdictions. So I was just wondering, in the process of your research, whether you see that as feasible in Sri Lanka, and whether or not it's actually got the opportunity of happening.
Thank you, Peter, for that question. In the context of Sri Lanka, there were actually two attempts to introduce it. The first one is the government tried to introduce a living entities policy. I actually attended several meetings regarding the framing of the living entities policy as well. But then again, the government changed. We got a new government and everything, and I don't know what is going on with the policy now. Perhaps they stayed it. That's how things work in our country most of the time. So that's one thing. And there was another case filed by an environmental organization called Center for Environmental Justice, because one thing to be understood about Sri Lanka is that in Sri Lanka, the environmental jurisprudence is basically led by the judiciary, not by the legislature or the executive branch as we would normally expect. So in this case, there is this World Heritage Site called Sinharaja Rainforest, and the government sought to build a road across the Sinharaja Rainforest, and then the public interest organization, they filed the case and asked the court to declare the Sinharaja Rainforest as a legal person. Then I recently followed up on that development, and I was told that the petitioners, they decided to remove that part from their petition and continue with the rest of it. So those are the only two developments that took place in Sri Lanka with regard to recognition of the rights of nature or legal personhood. But both, I think, they did not go ahead.
Okay, very interesting, the attempt there. So thank you.
Thanks, Peter. Excuse me. We might just try and get a collection of questions together now and then let Asanka answer those more or less in one response. So I see, Tom, your hand's up. I'll come to you in a sec. Is there anyone else in the room? David as well. Okay. Anyone else? No. All right. Tom, we'll just hear your question, then David will get your questions, and Asanka, if you can answer those. Yeah, exactly. Tom, go ahead.
Cool. Thank you so much, Asanka. That was really compelling way of trying to bridge, I guess, the Western and the non-Western view of the rights of nature. My question would be, can you see any structural reforms that would be helpful that go beyond what Western systems have right now, that would also further reinforce enshrining the rights of nature into our country? Thank you.
Oh, yeah. David, you okay with that one? Yeah, okay. David, go ahead.
Yeah, cheers, Paul. Yeah, really interesting. Thanks, Asanka. Yeah, really interesting kind of discussion on rights, balancing rights, and so on. My question is to do with, is using a rights-based approach here open to abuse potentially? For example, if you use a rights-based approach, are you going to lose some of those more traditional protections that a river might have, an environment might have, going for a more principle-based approach? And would that then be open to abuse by mining companies or whoever it might be? That would be my question.
Thank you so much. So I think regarding what you asked, of course, it's always going to be a limitation of rights of nature and legal personhood of nature, as I also pointed out, because it's not like the ultimate solution. It's just one mechanism that we can adopt. Of course, people might not even support it. I think that's exactly what's happening in Aotearoa and New Zealand, because they see it as confining their relationalities with rivers, their like the ancestral, all these relationships that they maintain with the rivers for generations. They see rights of nature evolution as a limitation, limiting, restricting their interests. So it can always happen. But in the context of Sri Lanka, I think we do not really we really need to have a mechanism to protect these entities and the relationalities before a court of law, because the customary laws and relationalities would not work anymore against the government decisions or the decisions of the big companies, etc., etc. So all these communities who do have deep relationalities, they do not have the, like the funding, the knowledge, or the power and everything to go against either the government or the companies. So the only thing that, as I see, that they can do is going to the court, because the court has always been independent in Sri Lanka, and they have always been very sympathetic towards the environment and the environmental protection, and they have always been eager to protect new environmental developments into the country and to widen the scope of the written black letter laws. So I think in the context of Sri Lanka, rights of nature would not be a limitation, but rather be a mechanism to expand the relationalities and protect the relationalities. And regarding what Thomas asked, other structural forms of I'm really not sure, because my research is basically coming from Sri Lanka. But then again, with regard to what I read about the indigenous communities and their relationalities to nature and everything, perhaps giving them the space to develop how they want to govern their own natural resources would be a better way of doing it, because I know in Australia truth telling and treaty is taking place, and it's a really good mechanism. Like the indigenous communities, they can participate, like the First Nation people, they can participate and they can say what kind of changes they want. So yeah, but then again, I don't think like we can totally overcome the Western domination of the legal systems, not in Sri Lanka, not in anywhere, because it's too embedded right now. I don't know. I think so. Yeah.
Yeah. Okay, thanks, David. Thanks, Tom, for those questions. I think that concludes the seminar for this afternoon. So thank you, everyone in the room and online, for joining. Thank you, of course, to Asanka. And I hope, that we continue to hear more developments and application of your ideas in the future.
Thank you so much. Thank you so much, everyone, for joining.
Thank you.
Thank you. Thank you.